record reflect that it is now 6:04. Governing board members present, please let the record reflect that we have Ms. Denise Garcia, Ms. Cassandra Hernandez, Ms. Rosa Cantu, and myself, Lidia Hernandez, board president. And for everyone's safety, we respectfully ask that no one approach the dais during the meeting, during a recess, or after the meeting adjourns. This includes walking past the podium. Thank you. And you'll please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. The Cartwright School District is located on the ancestral homelands of the Hohokam, Acamil Odom, and Odom Jude people, ancestors of the Salt River Pima Maricopa Indian Community, or otherwise known as SRP-MIC. We acknowledge the rich oral history, culture of these communities, and their ancestral ties to the land. Now, moving on to item number 4, the adoption of the agenda. I move that we adopt the agenda as presented. Ms. Cantu, do I have a second?
I second, Madam President.
Thank you, Ms. Cantu. And how do you vote?
I vote aye.
Thank you. And Ms. Hernandez, how do you vote? This is on the adoption of the agenda. Oh, you got to bring it down.
I vote aye.
Thank you. And Ms. Garcia, how do you vote?
Before I cast my vote, I'd like to
This is
just
the adoption
reiterate that
of the
this board
agenda?
remains out of compliance with the
Point
new
of
legal
order,
board. With
and
that
I
being
vote
said,
aye. And that motion carries. Thank you. Now we're going on to proceeding with the agenda. We have item D, which is a special meeting that we've called for today. The employee has requested public discussion of this item in a public meeting pursuant to ARS 38-43103A1 to consider and discuss the continued employment of the district's deputy superintendent chief financial officer. And at this time, I'd like to introduce attorney Mr. Nick Busan of Cantelme and Brown PLC. Mr. Busan.
Do I need to turn that on? Yes. Good evening, Board President Hernandez, members of the board, Superintendent Watson, and members of the community. My name is Nick Buzan, as was introduced. That's B-U-Z-A-N. I'm with Cantelme Brown. I'm an attorney there and have been for a few months and have been an attorney for 15 years in Arizona. The reason I'm here today is to bring this board and review a statement of charges against Ms. Farrar, and it's actually an amended statement of charges. This board is well aware that a statement of charges was brought on October 1st of this year, and the board at that time accepted the statement of charges and ordered that notice be given to provide 10 days to Ms. Farrar so that she could request a hearing. In due form, she did request a hearing. In the interim, information came forward that indicated that these charges should be amended. And that's when I got involved and started working on an amendment to this statement of charges. So that's what I'm going to go through today. I have reviewed the board meeting from October 1st, and I understand that the information that has already been covered is fresh in your minds, likely, but a refresher will be important, and it's also important for Ms. Farrar's rights that we go through the entire document again. So, as stated in the notice of special governing board meeting with executive session, pursuant to statute the open meeting law, the employee does have a right to have this in executive session. She was given notice last Wednesday, I believe, of this meeting. She immediately requested that this be pulled into open session, which is why we are conducting the statement of charges in open session. All right, now we are publishing on the screen the amended statement of charges, which I have in front of me, and we're going to go through it. That's fine. So a statement of charges, as you heard last time, is brought by the superintendent. The superintendent signs those charges, and then the board decides whether to accept them or reject them. It is not a trial. It is simply, it's kind of like an indictment. It's a statement of allegations, and we're going to go through the law and the policy that I believe was violated, which Mr. Watson has reviewed. And first and foremost, the relevant governing board policies and contractual provisions. So the allegation is that Ms. Farrar has breached her 2024 and 2025 executive administrator contract, and in the alternative, also her 2025-2026 executive administrative contract. If you could scroll down a little bit and just have the 3 at the top. So in this paragraph, number 3 there, it states that the administrator shall fulfill the customary duties of the assignment in the district. And scrolling all the way down, it says administrator shall act in accordance with applicable district policies. So that's what we're going to go through, is the policies that we allege to be violated. If you could scroll down. First policy is section B, the staff ethics. The administrator is charged with violating your governing board policy, GBEA, staff ethics, by not maintaining a high standard in their school relationships. This is a pretty broad policy, and I know that Mr. Brown went over this in a little detail, so I'm not going to spend a lot of time on this one. If you could scroll down a little bit.
Excuse me, would you mind going over that a little bit, because that's kind of confusing to me.
You're confused by this paragraph? I can read it for you, if you like.
Yeah, because there's a question I have relating to that.
Okay. So staff ethics policy has several specific portions of the ethics policy that I believe were violated. I'm going to go ahead and read the paragraph that opens up to that, and it just states that all employees of the district are expected to maintain high standards in their school relationships. These standards must be idealistic and at the same time practical, so that they can apply reasonably to all staff members. The employees acknowledge that the schools belong to the public they serve for the purpose of providing educational opportunities to all. However, every employee assumes responsibility for providing leadership in the school and community. This responsibility requires the employee to maintain standards of exemplary conduct. It must be recognized that the employee's actions will be viewed and appraised by the community, associates, and students. To these ends, the board adopts the following statements of standards. If you could scroll down. All right. The school employee, B, maintains just, courteous, and proper relationships with students, parents, staff members, and others. I believe the allegation in this against Ms. Farrar would be particularly in her relationship with staff members and others. D is fulfills job responsibilities with honesty and integrity. The heart of the allegations in this matter are that the employee was not honest in her dealings. E directs any criticism of other staff members or of any department of the school system toward improving the district. Such constructive criticism is to be made directly to the school administrator, who has the responsibility for improving the situation. H, implements the governing board's policies, administrative rules, and regulations. I, refrains from using school contacts and privileges to promote political or sectarian religious views or personal agenda of any kind. I added this one. It was not part of the previous statement of charges because I believe the facts, as you'll hear them, indicate that Ms. Farrar is at least allegedly operating for an agenda that was not what was just stated in the policy. It was another agenda.
What was that agenda?
I'll get to the facts and I'll let you answer questions or ask questions at the end if you would. M, stresses the proper use and protection of all school properties, equipment, and materials. C, violation of governing board policy GBP, prohibited personnel practices. The administrator is charged with violating policy GBP, which provides in pertinent part, it is prohibited personnel practice for any district employee who has control over personnel actions to take reprisals against another employee for a disclosure of a matter of public concern by that other employee to a public body when the employee believes there has been A, a violation of law, or B, mismanagement, a gross waste of monies, or an abuse of authority. D, policy. This is also amended. Initially, the policy GCQF was stated, and we went ahead and added GDQD, which is just to be safe to make sure that this allegation applies to Ms. Farrar in her capacity as an employee here. So under GCQF, administrator is charged in pertinent part. Certificated staff members may be disciplined for infractions that include but are not limited to the following categories. A, engaging in unprofessional conduct. E, exhibiting improper attitudes. F, neglecting their duties. G, engaging in acts of insubordination. In GDQD, this is subsection K. I, engaging in acts of dishonesty, which is subsection F in GDQD. And then administrator is also charged with violating policy GDQD, which provides in pertinent part that term employees, the employment of a term employee may be terminated for cause by action of the governing board at any time prior to the expiration of the term of employment. For the purposes of this provision, cause means any conduct that in the judgment of the district is detrimental to the interests of the district or its personnel or students, and shall include without limitation thereto the following: F, dishonesty; K, insubordination; L, neglect of duty; R, violation of a district policy or regulation. E and F are also two policies that I added in the amended statement of charges. Policy CB is a superintendent policy. It states that the administration of the school system in all aspects is the responsibility of the superintendent, whose functions shall be carried out in accordance with the policies of the board. It's my contention that after you hear the facts of this, you will conclude that the employee was usurping the role and duty of the acting superintendent and therefore violating this policy. F is violation of governing board policy CBA, qualifications and duties of the superintendent. It's a superintendent's duty to supervise either directly or through delegation all activities and all personnel of the school system. The superintendent is the district's chief executive officer and the administrative head of all divisions and departments of the school system. It is the superintendent's duty to administer the policies of the board and to provide leadership for the entire school system. Finally, personnel. Under the personnel duty of the superintendent is responsible for communicating to all employees all actions of the board relating to personnel matters and receives from employees all communications to be made to the board. So as you'll hear, the allegation is that Ms. Farrar was acting as the superintendent and not consulting with the superintendent, and that's the violation of that section E. All right, the specific factual allegations supporting this statement of charges these are similar to the first statement of charges and set forth below. Support the charges that administrator has engaged in conduct that violates governing board policies and administrator's employment contract with the district. A, administrator has been the district's deputy superintendent, chief financial officer since 2020. B, administrator entered into an employee contract with the district for the 2024-25 fiscal year from July 1st, 2024 to June 30th, 2025. C, administrator entered into an employment contract with the district for the 2025-2026 fiscal year from July 1st, 2025 to June 30th, 2026. D, paragraph 3 of administrator's employment contracts for both 2024, 2025, and 25-26 are identical. They provide in pertinent part that administrators shall fulfill the customary duties of the assignment in the district, those obligations imposed by state law, and such other duties as from time to time may be assigned to the administrator by the superintendent or board. Administrators shall act in accordance with applicable federal and state laws, district policies, administrative regulations, and procedures as they currently exist and as they may be modified or created during the terms of this contract. E, administrator oversees and is responsible for the district's business services department, which includes procurement, accounting, payroll, and accounts payable. F, Dr. Derek Etheridge, Executive Director of Business Services, reports directly to administrator. G, the district, specifically the Business Services Department, is required to ensure all filings required by the Internal Revenue Service are made in accordance with IRS rules and regulations. Specifically, the district is required to file IRS Form 941, employer's quarterly federal tax return, and remit applicable withholdings. In addition, the district is required to file information return IRS Form 1094C, transmittal of employer-provided health insurance offer and coverage information returns, and provide employees with IRS Form 1095C, employer-provided health insurance offer and coverage each year. H, in 2017, the district failed to file Form 1094C with the IRS by the due date, which resulted in fines, penalties for failure to file. I, in addition, during the first 2 quarters of fiscal year 23-24, the district did not properly report wages on the IRS Form 941. Therefore, although tax withholdings were remitted, they were remitted in the wrong period. This resulted in an assessment for late filing. J, although the district made attempts to have any fines, penalties, or assessments for these violations abated, its efforts were unsuccessful. The final result was payment of fines, penalties of approximately $2.2 million. K, in July of 2024, Administrator Director Dr. Etheridge to pay the IRS fines and penalties. Payment of the IRS fines penalties was discussed in the Superintendent Executive Leadership Team meeting prior to payment being made. L, on July 31st, 2024, at the direction of Administrator, Dr. Etheridge pushed through the purchase orders to pay the IRS fines, penalties, and payment was made on August 1st, 2024. M, at the September 12th, 2024 Governing Board meeting, after payment of the IRS fines penalties had already been made, the vouchers for the payment of the IRS fines penalties were presented to the Governing Board for approval. However, the Governing Board was only provided with the cover page of the voucher. Therefore, without significant research and study, it would have been very difficult for Governing Board members to know what the expenditures were for. N, upon information and belief, as of the September 12, 2024 meeting, the Governing Board, collectively and individually, were unaware of the IRS fines, penalties, and payment of the fines penalties. O, the Governing Board was not specifically notified of the district's payment of the IRS fines penalties until January or February of 2025. P. In January 2025, two new governing board members took office, which changed the power structure of the governing board. Now, these are the facts that are different from the last statement of charges. They are in the same time frame of the sort of investigation that was occurring around Mr. Etheridge's statement, but they are on a separate issue. So I just note that to make it easier to follow. Q. On January 15th, 2025, Superintendent Emma Wadigi was placed on administrative leave. On or after January 16th of 2025, Interim Superintendent Emma Wadigi was presented with and received a Notice of Leave Rights and Obligations form. This is her paid administrative leave Notice of Leave Rights and Obligations. S. The Notice of Leave Rights and Obligations stated in pertinent part, and this is really crucial to what is the allegations that of the policies that were violated. While on administrative leave, I understand that I am not to access the district's computer system, internet, or other district files except as instructed by district administration. T. On January 23rd, 2025, Steve Watson was appointed by the governing board as acting superintendent. As the acting superintendent, Steve Watson is responsible for oversight of Emma Wadigi's administrative leave. U. In January 2025, in an effort to be transparent, now this is going back to the original allegation, but it's so bear with me, it's in the same time frame though. In an effort to be transparent, Dr. Etheridge prepared a list of payments that had previously been made by district administration without governing board approval that exceeded the $100,000 limit established by the governing board. It was governing board policy that any payments in excess of $100,000 had to be specifically approved by the governing board. Dr. Etheridge, in collaboration with the procurement supervisor, prepared this list to ensure the new governing board was aware of expenditures exceeding the $100,000 limit. V. Dr. Etheridge believed that his employment would have been in jeopardy if he had taken the IRS fines penalties issued to the governing board prior to January 2025. W. Despite directing Dr. Etheridge to pay the IRS fines penalties in July of 2024, and despite knowing that the governing board approved, unknowingly, the IRS payment vouchers at its September 12, 2024 meeting, administrator told acting superintendent Steve Watson during a February 11th, 2025 superintendent executive leadership team meeting that she did not know that the payment to the IRS had been made. And I should have noted at the beginning of this document that anytime the word administrator is used on its own in the statement of charges, it's referring to Mrs. Farrar. X. Administrator's statement to the acting superintendent and the executive leadership team was false. Y. Dr. Etheridge and Christine Santos, executive assistant, who attended this meeting, heard administrator make this statement to the acting superintendent. On February 18th, 2025, after telling the acting superintendent that she did not know that the IRS payment had been made, administrator issued to Dr. Etheridge a notice of intent to impose discipline, which provided in pertinent part. B. Executive leadership. Little I. Lack of critical thinking when asking the board to approve a purchase made 6 months before, when in open discussion in leadership. In executive leadership, the IRS fees were to be taken to the board for approval, yet the expenditure and voucher cover sheet was already signed. Subsection 2. Lack of understanding that the notification to the governing board should have taken place well before February 2025. In fact, there were opportunities in September, October, November, and December of 2024 to bring this to the attention of the governing board. AA. Although administrator did not ultimately impose discipline against Dr. Etheridge, He felt that the notice was retaliation for him coming forward to make sure the governing board and acting superintendent were aware of the IRS fines and penalties. Now I'm shifting back to the amended allegation. B. On January 28th, 2025, administrator intentionally provided access to the district's computer system, internet, or other district files to administrator on leave, Emma Wadagi. Administrator intentionally did not notify the acting superintendent that she was doing so. C. On February 11th, 2025, administrator directed IT department employees Philip Sang and Mike Dismukes to provide employee access to administrator on leave, Emma Wadagi. Administrator misstated attorney advice to enable Ms. Wadagi access to the district computer system beyond the stated reasons. Ultimately, administrator enabled Mrs. Wadagi access to her email address, the entire suite of Google applications, and any other programs not specifically identified herein. D. Upon information and belief, administrator delivered Mrs. Wadagi her password to enable access to the district computer system and district files without notifying acting superintendent Watson or the governing board. E. Administrator enabled Mrs. Wadagi to have email access to the district computer system between February 11th and February 20th without approval from the acting superintendent or governing board. Now, the communications surrounding this can get a little confusing. There are separate periods of time, and that's why I'm indicating between February 11th and February 20th. The allegation is that Mrs. Wadagi had full access to her email address and all of the other files. That changes on February 20th.
So in order for her to access, for example, employee benefits, I'm just throwing that out there. Did you hear what I said?
No.
I did not.
Okay, I will repeat that.
Thank you.
So, if an employee, our superintendent, Emma Hadagi, if she, being on admin leave and had questions, for example, benefits, I'm not sure what the email was about, but just say benefits. So in order for her to obtain any type of personnel, meaning her benefits or whatever she was looking for, she would need access to her email. Otherwise, how would she be able to access her benefits?
I believe the rest of the facts will help
Okay.
to answer your question, and I would ask that you hold the question until the end, and hopefully the facts will answer that question.
Okay.
Is that okay?
Thank you. Sure.
All right. So, EE, I believe I'm on EE. Administrator enabled Mrs. Wadagi to have email. Actually, I already said E. FF. On February 19th, 2025, Deputy Superintendent Grijalva requested that IT close Mrs. Wadagi's email access. Administrator declined Deputy Superintendent Grijalva's request to close Mrs. Wadagi's email access, stating, quote, "In order for Emma to continually have access to her pay statements, we have to keep her email active." This was a false statement, as Director of Business Services Etheridge printed Mrs. Wadagi's pay stubs throughout February and March. An administrator never communicated to Mr. Etheridge that she was enabling email access for Mrs. Wadagi. GG. On February 19th, 2025, administrator concealed her request to provide access to Mrs. Wadagi in a Microsoft Teams message to IT Director Sang. For example, and this comes directly from the communication, it's in bold, states administrator, that is Mrs. Farrar. She says to Mr. Sang, "Confidential. If anyone else asks to turn off Emma's email account, let me know ASAP." Director Sang, So she, referring to Dr. Grijalva, said, turn it off and mail the pay stubs. Are we turning it off? Administrator, not yet. HH, on February 20th, 2025, Administrator reiterated her directive to IT to conceal Mrs. Wadagi's access to the district computer system. Administrator specifically stated that this information should be, quote, highly confidential and only amongst the four of us, no one else, end quote. II. On February 20th, 2025, Administrator directed IT to maintain Mrs. Wadagi's access to the district computer system. She specifically and intentionally did not communicate this request to Acting Superintendent Watson, the Director of Business Services who oversees IT, or the Governing Board. JJ. On April 7th, 2025, Acting Superintendent Steve Watson learned for the first time that Emma Wadagi had access to email authentication when she emailed in that had been inadvertently turned off. KK. Administrator's intentional and deliberate action enabling access to an administrator on leave during an investigation impeded the investigation into the administrator on leave. LL. Acting Superintendent Steve Watson was neither aware of the access provided by administrator, nor would he have consented to it. In conclusion, the above charges and specific facts support a finding that administrator has engaged in conduct that violates governing board policies and constitutes a breach of administrator's employment contract. Accordingly, the acting superintendent hereby recommends administrator's dismissal pursuant to ARS 15341A22 and 15-539. Included with the statement of charges were copies of these governing board policies, copies of the statutes listed therein, and that is my submission. I am here for questions.
I have questions. There are several. One being, okay, in making reference to, you stated, you're talking about honesty and integrity, lacking honesty, admin rules, regulations. With everything that you presented this part that you just went over, but everything else is, it seems as if you're gathering this information from other employees. So what I'm looking for is hard evidence. I see what you just presented, but prior to that, what about other evidence? For example, in addition to that, Dr. Etheridge had presented at one point here, and you also made pardon me, let me back up a little bit. 2017, you made reference to IRS fees. That was in a different administration. So that was an administration that had failed to pay the IRS, which followed forward. And so following that, you're looking at those penalties in addition to other penalties that had incurred. Now, Dr. Etheridge, during his presentation, had stated that he was basically negligent, that he failed to provide oversight to his employees. He stated that right here. He owned it, and so I'm kind of confused about that because he also made reference to the fact that he did it on his own. Again, failed the supervisory role that he had, and then submitted the vouchers. So you're talking about two different people here, except what you're doing is you're alleging that it was Miss Farrar when it was Dr. Etheridge. Okay, and another thing, let me see. Wow, there's a lot. That was quite a fishing expedition. I will say that.
I'm
Okay.
sorry, is there a question?
Yeah, one moment, please. Okay, in addition to that, you also stated that her relationships were, she lacked integrity, did not have positive relationships with employees and others. I'm not sure who you were referring to, but there's a lot of information that you have provided here that doesn't have any evidence to support your claims.
Okay, I think the question is there evidence to support the claims? And I
Yes.
think the first time that Mr. Brown presented this to the board, there were similar questions. The allegation against Ms. Farrar for her interaction with Mr. Etheridge and the $2.2 million payment have nothing to do with the presentation to the board, the lack of transparency that surrounded that. The allegation is specifically to Mrs. Farrar's false statement to the acting superintendent on, I believe, February 11th in the executive team meeting. I could have the date wrong, but it's here in the statement of charges. So that's the first allegation, and that's where relationships with others, that's all I'm saying about that.
Oh, okay. So speaking to that, I appreciate that comment. So, or statement. Speaking to that, as a board member, I mean, I'm not sure what Mr. Watson's communication is with other employees, but as a board member, he has not responded to my emails. So that's concerning. So is there integrity there or is there not? I would be quite concerned.
Ms.
And
Garcia,
I would be
is there a
remiss if I
question
did not bring that
pertaining
out because
to what
who
the item
knows
on the
what type
agenda?
of allegations
Point of
are.
order.
Point of order, Lydia.
Point
Yes.
of order. We're moving forward. This was, you were offered an opportunity for questions. We're asking for the question, not your comments.
This is called transparency.
I
and
think
what
I
I'm
can answer the
asking,
question.
Oh,
yeah,
I think I can answer
I'm
the
still
question.
waiting for.
Yeah.
These, your analogy about Mr. Watson, not responding to your emails, that's not what the allegation is here. The allegation is that she said a false statement, which she knew to be false. She stated she did not know about the payment, which is demonstrably false. That's the allegation of dishonesty on that. The second piece is that she retaliated against Dr. Etheridge for bringing this information forward and signed a notice of intent to impose discipline and then ultimately didn't impose it.
I think that if
But
any,
that's the second allegation.
okay,
The last allegations of dishonesty are that she did not notify Mr. Watson, the acting superintendent, who this board duly hired to be the acting superintendent, that she was providing employee access to the former superintendent who was on leave. Those are the allegations, and that's what the dishonesty allegation is.
okay. So speaking to, again, Dr. Etheridge, if any employee, not just him, any employee had been negligent or had not provided the utmost care and efficiency in repaying, for example, the IRS, any employee, not just him, we would all be held accountable. Any of us could be held accountable, and that would make sense because in any job, if we fail to produce or be productive in our role or negligent in our role, that would make sense. Yes, there would be discipline and there would be
Right, but
reprimand.
to the
reprimand.
retaliation
So,
claim, though,
I'm not, yeah,
that's,
but I'm not sure
we're talking
where
about-
does the retaliation come from? That's what I want to know.
well, it was dishonest because she had knowledge, firsthand knowledge, that the payment was made because the allegation in here is that she directed him to make the payment and then punished him for telling the board about it. So that would be retaliating against somebody for trying to assist the district or doing the right thing. So there is no negligent act in that. I understand what you're saying, that Dr. Etheridge has other negligent acts. I don't know. I didn't investigate all that. Only here to talk to you about the statement of charges here
And
against
then,
Ms. Farrar.
okay, I appreciate that. And then I guess one more question for now would be if Mr. Watson was aware of any type of disruption or negligence as a supervisor, was there any type of coaching? Did he meet with her? Did he write her up? Did he speak to her? I mean, was there any type of communication? Because from where I sit, it looks like these allegations have been made based on, I want to say hearsay, but based on communication with other people. But when I ask for evidence, I'm asking specifically, was there a meeting? Was there a write-up? Did he perform his duties to meet with her and have these discussions or not? And that would be evidence that I'm asking for. Thank you.
With regard to Mr. Watson's coaching or discipline for these dishonest statements, allegations, I can speak to the last three. He was not aware of the allegations against Mrs. Farrar until recently, until she was already placed on leave. Sometimes being placed on leave is just that, an opportunity to investigate and look at what the allegation is, and sometimes a letter of discipline is the result of being put on leave. Under this circumstance, the choice was made to make a statement of charges, and I will say that in my experience, when you are talking about the executive level cabinet, that honesty and integrity and truth between deputy superintendents and superintendents is an absolute necessity.
I
And
agree
so the
100%.
allegation,
I do.
okay.
So, excuse me for one moment. Speaking to that and what I just mentioned. So, in any supervisory role, anyone, if there is an employee who has not produced, again, been deficient or negligent or whatever that may be, even if an employee needs coaching, it is a supervisor's responsibility to meet with that employee, to have these discussions, to talk about in writing what's happening, this is happening, let's talk about this, what's going on. What I see here is none of that. What I see here are basically allegations, that's it. No hard evidence other than what you just showed us. One thing.
The quotes that I indicated in the statement of charges are from emails by Mrs. Farrar and
Okay.
Teams messages by Mrs. Farrar, and together amount to the hard evidence that we have.
At the very beginning, what
Collected.
about the IRS penalties? That's another one. So that has not been hidden. Well, for a time being, it was until it was brought forth. And so I really don't know too much that's going on here because this board does not share anything. So I find out basically when the public finds out. So what I'm doing is I am a public servant and I am here to serve, not just one person, but the entire body if I can. And this is transparency at its best. So with that being said,
Question?
I am wondering why this statement of charges to the IRS is still here when, I mean, there are several, but that's the big one of the big ones.
The statement of charges has to do with
Speaking to the IRS penalties.
regard to the IRS penalties and fines. The statement of charges is for lying to acting superintendent Mr. Watson when it was asked whether she knew about the payment. That's what it is. It doesn't have to do with, this is not a deep financial investigation into the payment. Obviously, the district would have loved to take that back. I'm sure all the employees in that department would have, and the board itself would be happy if that never occurred. That's not what this case is about. This case is about a false statement made to her superior.
Okay, so one or a false statement. So what about everything else? All of the other allegations?
The other allegations are also lies of omission. They're dishonest acts to provide access to an interim superintendent who was placed on leave by this board and given a notice of obligations not to access the district computer system or files or internet without district administrative authority. The allegation is that Mrs. Farrar, in concert with others, worked to ensure that she had access and conceal that from the acting superintendent, Mr. Watson, and thereby conceal that from the governing board. Mr. Watson should have had that information. He should have had information that Mrs. Farrar was providing access to Mrs. Wadigi, or that Mrs. Wadigi had requested access. He should have had that information, and the board should have been able to have that information. And especially when Mrs. Wadigi was on leave undergoing her own investigation. So to provide access to somebody while they're on leave brings up lots of suspicion. There is no proof that it impeded the investigation. I don't have evidence of that, but to provide access leads to the conclusion that somebody was attempting to enable the investigation to be impeded.
You also stated that Dr. Etheridge would mail out, speaking to Ms. Hadigi, our superintendent, that he would mail out her paycheck stubs. Is that accurate?
He did. He was asked in a meeting on February 19th with Mrs. Farrar to mail those out. And the information that Dr. Etheridge had was that they needed to be printed, that her pay stubs and direct deposit statements would be printed and mailed to her. And that's where the quote, confidential, quote, highly confidential communications come into effect, is that Mrs. Farrar, in a separate communication with only 4 people, including herself present, enabled Mrs. Wadigi's access to the computer system and let Dr. Etheridge just continue on sending those pay stubs. And so he was in the complete dark with Acting Superintendent Watson on that issue. That's
you.
the allegation.
Okay, yeah, exactly, an allegation. And so speaking to another allegation here, or actually not really. So the benefits, I mentioned the benefits because what you referred to were paycheck stubs. So if an employee is sent home on admin leave, how would they be able to access information or to change or update information of their employee benefits?
That has been occurring with employees on leave here at the district. I don't want to break any confidentiality of other employees. We're only here to talk about one employee who requested that this be an open session. But I do have information that the district is capable, and I know Mrs. Wadigi herself called in and requested information, has requested beneficiary changes, has made other requests for her employee benefits, etc., since being put on leave. So it is possible without providing digital access.
And that would speak to all 3 employees who are now on admin leave, correct?
I can't speak to all 3 employees that are at admin leave. We're only here for Mrs. Farrar. For that one employee, Mrs. Wadigi, who happens to be the subject of the access here, it was provided.
Okay, the reason I asked about all 3 is because you mentioned all 3. Thank you.
There are multiples that is permissive. I know that it occurs and it has occurred, and you don't need email access to get the information that you're requesting.
I appreciate that. I'm just trying to confirm that they have received what they've been asking for, if in fact they are asking for those items. Thank you.
Are there any other questions from the board? I do have a question. You began by stating a background of the previous presentation that had been done that we are going back to, since there's been added information to the original statement of complaint. You read off several of the board policies, which might make it sound somewhat confusing. But what are the board policy? Why are they there? What is the role of board policy to the governing board?
The governing board policy and regulations are really the rules of the board. Arizona statute, largely in Title 15, you're all elected officials, either elected or appointed to this board to serve your community. You act under the force of law. You make legal decisions under the force of law, as you all know. Arizona statutes speak often of the governing board shall adopt a policy for a particular reason. It does give some discretion to the governing board on many issues. The Cartwright School District's governing board policy manual is all of the policies that enable you to set the rules for the district. Those policies must be compliant with Arizona statute. They can never be inconsistent with Arizona statute. But like I said, there are many areas where you do have discretion as a board to adopt a policy. The legislature gives you one direction to go, or you can choose one or another. It's often said that school boards are a creation of the legislature, and so that's why the legislature can amend the rules that you have to follow. And so your governing board policies are just that. They are your rules consistent with the state legislature, and your regulations are essentially your guidance to the superintendent, where the superintendent will act almost as the governing board does with the legislature. He or she may never have regulations that are inconsistent with what you do, and but it's a little bit of discretion there that the governing board will provide to the administration to use in regulation.
So when I was listening to the board policies that you were mentioning, there were the expectations outlined by the district, by our rules. There are rules, there's policy to support our behavior, everything that we do. We're elected by our constituents to really govern this district. And I've mentioned before, and I've walked us through the process of those limitations as well. So we only have that power when we're convened together. And my understanding is that as board, even as board president, because I do meet to prepare the agendas for items that need to be discussed that we're going to be taking, or we would need to take action on. And the only person that we are able to have I'm looking for the right word. We work with the superintendent directly. It's the only power that we have in that meeting. So I do not, as board president, nor as a member, do we have the powers, or at least the policies do not, as I understand them, don't give us that power to either investigate, to accuse, to make allegations against, to direct staff in isolation. The reason that I point this out is because previous meetings I've outlined our board process, which gives us those limitations. So when we're discussing statements of charges,
Point of order.
there are violations that have taken place of those board policies that outline the expectations or how we're going to behave and perform our duties.
Point of order, please.
Is that correct? Do I understand it correctly?
Yes, absolutely, Board President Hernandez. I think the Arizona School Boards Association will talk about roles and responsibilities oftentimes, and the governing board's policies, when adopted by a duly elected governing board, outline what those roles and responsibilities are for what's often stated as your only employee, the superintendent. And I think you've done a good job of summarizing that.
So these, I know I have a question regarding the allegations. Do we have, are these allegations supported by evidence?
That's what I asked.
The documentation from the statement of charges where you see a quoted item is a direct communication by Mrs. Farrar. There are additional witnesses to those statements who received it. And so, yeah, the answer is yes. They are supported by evidence. And Mrs. Farrar was also given an opportunity to be interviewed about this. And I won't go into the details here because this is a hearing, and
Right.
this is not the hearing or the time for that. But there are emails and Teams messages from all of the dates that I mentioned in the statement of charges, including February 11th, February 19th, February 20th.
I have a question. Speaking to
Thank you for that.
the payments to the IRS. Was Ms. Farrar ever asked when she learned about the penalties or the payments that were due to the IRS? Was she ever asked? Was she ever notified when Dr. Etheridge was informed, or however it was he was informed about the penalties?
Subsection K states that in July of 2024, Administrator Director directed Dr. Etheridge to pay the IRS fines and penalties.
When was she informed of the penalties is what I'm asking. Because apparently when he did notify her, then she moved forward to make that admin move and have him pay the fees. When was she notified? Was it in a timely manner? Was it, I don't know, what is the answer to that question? Was she notified in
That's
a timely
beyond
manner?
the scope of
Well, not really, because you're
these
talking about
allegations.
allegations. You've been speaking about allegations since we arrived. So what I'm asking is, was she ever notified about the penalties, about the payment?
The evidence is clear that she is aware of the payment and
Now
that she
well,
directed him to make that in July of 2024.
when
She was
found
also the
out.
CFO since 2020. That's subsection A. Since 2020, she's been the CFO. I do not know when she found out about the penalty or the payment. I know that she directed the payment, or at least that's what
Right.
the allegation is.
And that's what I'm making reference to, because if she was notified, of course she's going to go ahead and make that a requirement pay, which makes sense. But when was she notified? Was it in a timely
What's
manner?
interesting
Was it
about
after
this?
the fact?
What's interesting about this that actually pertains to the amended statement of charges is that the notice to impose discipline didn't have to do with not telling Mrs. Farrar about the IRS penalty. The notice to impose discipline had to do with telling people, bringing this to light. It didn't have to do with hiding it. She attempted to impose discipline for Dr. Etheridge bringing it to light. That's the allegation. So your contention that he hid it from her or didn't tell her for some period of time, I don't know. That's not, presumably, she would have imposed discipline for that. And maybe she did it another time. I don't know. All I know is that from February of 2025, she did not intend or she did not attempt to impose discipline for that.
So if Dr. Etheridge is stating that he feels this is retaliatory, and he is stating that it occurred after, or he was told not to tell people, that is, he says, she says, or right? That's an allegation. That's not in stone. That's not recorded. That's not evidence, or is it? I don't know. Repeat that?
Yeah,
Okay.
if you could repeat that.
No problem. So he, according to what you just read, he stated, Dr. Etheridge stated that he felt retaliatory by Ms. Farrar because he told people. That's what you said.
Well,
He told
I
four
read
people.
directly from the notice of discipline. It's section Z.
Okay.
We should have page numbers on this. I apologize. Hopefully this will never have to happen again, but if it was, we'll put page numbers on it. Z states on February 18th, 2025, after telling the acting superintendent that she did not know the IRS payment had been made, Administrator issued to Dr. Etheridge a notice of intent to impose discipline, which provided, in pertinent part, lack of critical thinking when asking the board to approve a purchase made 6 months before, when in open discussion in leadership. In executive leadership, the IRS fees were to be taken to the board for approval, yet the expenditure and voucher cover sheet was already signed. 2, lack of understanding that the notification of the governing board should have taken place well before February 2025. In fact, there were opportunities. So this subsection B here is the language that Mrs. Farrar crafted to impose discipline to Dr. Etheridge. So she's alleging that he should have came forward sooner when he told the community or the executive leadership or the governing board about the September payment.
That would appear appropriate with any supervisory position where they are looking for accountability from an employee. Thank you.
I just another question, attorney. The board policy authorizes the superintendent a limit, a threshold, an amount of dollars that he can make payment. He has the authority to make payment on his own. But after, I think you mentioned 100,000 is our board policy. So why a decision like this would be important would be because obviously this amount 2 million exceeds the 100,000. So therefore, should the board had been informed of such um amount to be expended?
Yes, and the allegation is in subsection M that at the September 12th, 24 governing board meeting that it was governing board approved, but that the information to the board was not transparent enough and that the governing board never really knew about this payment until Mr. Etheridge came forward in January of 2025.
And just for the record, from my recollection of the September 12th meeting, two board members did not have access to that agenda, and it was blamed on a glitch to Board Docs, which is the app that we use to disseminate and ensure that all board members have access to the agenda. If you review the minutes of that meeting, we questioned, we spoke to IT staff. They couldn't explain why even it was not even showing up on Board Docs, but they blamed it on a glitch. Therefore, for the record, two board members didn't have access even to look at prior to the meeting, nor during the meeting until we got to the meeting, and after the fact. But I pointed out also in the past meetings, for those in the audience and those watching, that the board provides oversight for the constituents. That's why we're elected. And when we review the agenda and the superintendent brings me an agenda, I go through the items. And so I have to apply due diligence to ensure that I know the rationale behind each item being expended, and I have the opportunity to question. And I will, in some more than often more cases, ask for additional information if it's not clear. In the month of January, I had made clear to our acting superintendent that if there were going to be items that were going to be brought forward, that I would question and I would expect a complete rationale. So when, in fact, I saw a large amount coming before, I had made clear as well that I wanted that explanation. In fact, I think you went to review and got that information because I was not willing to approve an item that I didn't have any information on. I was fearful even at the time, as you can understand, that if something was paid or not paid, it wasn't clear to me. And after the fact, after February, I was informed that it had already been paid. So I was afraid that I was signing off. I refrained from signing off on any invoice because I'm questioning where's the other 2 million going to be going to? If the lie was that we needed to pay for it because we were accruing fees, but then then it was not only confusing, but I was extremely fearful that nobody could explain where that if I'd signed another check where the 2 million were going to be paid, if that had already been paid. The only difference here was that the board had not been informed. So I clearly understand, according to our board policy, the violation, and thank you for clarifying that for me.
I have two more questions.
Ms. Garcia?
The first question is, do you have in your information right there, do you have the date of when Ms. Farrar found out about the payment, when she was informed about the payment to the IRS? That's one question. My second question is, you brought up Ms. Hadigi a few times. So speaking to Mrs. Hadigi, our superintendent, is there a report that was pulled from the database that will show what exactly she was looking at?
The answer to your first question is no, I don't know the answer to when Mrs. Farrar learned of the IRS payment. Number two, we did do our due diligence into Mrs. Wadagi's access, but that's not for the subject of these statement of charges. And in fact, I don't think it would be appropriate for me to share any information about Mrs. Wadagi. The only reason that I'm speaking about her at this stage is because she is a party that is part of the statement of charges in reference to who the access was provided to. But this is not about what she looked at or what she didn't look at. There's no relevance to that. That would be for an allegation against her if there was one, and I'm not saying there was. And so that would be a separate investigation.
Okay, I'd appreciate that. And so speaking to Ms. Farrar, there is nothing there that states the date that she was informed about the payment to the IRS?
No, that has not been relevant to this amended statement of charges.
It seems that it would be extremely relevant based on the charges.
In July of 2024, she directed Dr. Etheridge to push the payment through. And in February of 2025, she told Acting Superintendent Watson that she did not know about the payment. That's the allegation against Mrs. Farrar.
Okay, so if she said that she did not know about the payment, I'm not sure what that discussion looked like. But what I am asking again is when, based on whatever investigation you've already had with her or whoever while meeting with her, when did she find out about the payment? That's what I want to know. I think it's relevant. I believe it's relevant. And again, I heard what you said. You're, using the dates that you have there, but you still haven't answered that question. When was she notified? The date, which might speak to some of this. And again, as
Okay,
Lydia,
Ms.
as
Garcia, I
Lydia
think we've
has
got the
mentioned,
question.
we are here to.
We've got the question. We've got the question.
Hold on. I still have the floor.
Point
Lydia.
of order.
Point of order, Lydia.
Point of order.
I believe
Attorney,
it would be justification to make sure that
do we need
are
to get a
doing our
recess?
due diligence and making sure that we have all of the information in stone. As
I'm happy to
Thank
answer
you.
any question you have if you have a question. But
Yeah, I'm just asking that question. Was she?
it's
yeah.
beyond the scope of the amended statement of charges.
Okay, but it's within the charge. So you're
No,
saying
Okay,
it
point of
has
order.
nothing to do-
Point of order.
You're
We're
saying
moving
it's-
forward. Ms. Garcia, point
you're
of
saying it's
order.
beyond the
If you
charges,
understand,
but
that
I am
means
saying that it
discussion
is
is
not. It is quite
over.
relevant.
Attorney Busan, I do have a question. If you could clarify, I think we're going around in circles with a question that is not relevant to the statement of
It
charges
is
that we're
relevant
here to
because it's a
discuss
charge.
today. So, for the record, for clarification, we are here because this is like jumbling things up. So, the statement of charges, if you could just reiterate the statement of charge with the addition. I understand that there is, based on what you've already discussed and mentioned, there is supporting evidence for the statement of charges. I want to be clear that there are the questions that Ms. Garcia is trying to ask is not relevant because it is not relevant to the actual statement of charges. It's other information that she would like to know that is not pertinent to what's being discussed at this point.
It's part of
For
the
the clarification, could you please just
it is part of the
reiterate
allegation.
what
is
were
in
the
there.
violations that this employee committed that brought us to this point? I mean, to the termination.
And did her supervisor
I
ever meet
have
with
the
her?
floor.
That
Attorney
again,
Busan,
was
if you
there
could
ever
please
a
if you
move
meeting?
forward.
like, I can summarize it for you.
Was
one
there
last
ever
time.
a meeting between Mr. Watson and Ms. Farrar to discuss allegations or discuss a reprimand?
If we could just move forward with the question that I asked.
I asked a question also. Thank you.
I don't even remember that anymore.
Lydia, you talk about following the rules, but
We
yet
are
you are the one
going
that does
to,
not. You
uh,
talk about following policy,
I have
but you
point
do
of
not.
order. I have
Point
the
of
floor.
order,
And
yes.
if we can allow, you are not allowing, your behavior here is very clear that you do not want to allow for the statement of charges to be stated for the record. I've
I am
asked the
being
question,
transparent,
allow
Lydia. I'm
this is
looking for
this is being
transparency.
transparent. For the record, please, attorney, if you could please just respond for the clarification purposes.
Sure. The $2.2 million payment to the IRS for fines and penalties is not what Mrs. Farrar is alleged to have done correctly or incorrectly. And when she knew about it is only relevant to the extent that it proves that she made a false statement to the acting superintendent. So the allegation is that, number one, Dr. Etheridge came forward with this $2.2 million payment to the acting superintendent in January of 2025 in an effort to be transparent. At a meeting in February of 2025, Mrs. Farrar, when asked in front of three people, at least three people, stated that no, she did not know about the $2.2 million payment. All of the facts that are leading up to that in the amended statement of charges are to demonstrate what that significant lie was all about. Allegation number two. On February 18th and February 19th, Mrs. Farrar brought a notice of intent to impose discipline against Dr. Etheridge for providing that information to the people 6 months after she says he should have. To the people, I mean to Acting Superintendent Watson. She said that that was an unprofessional act on his part, and so she was intended to write him up. Ultimately, I'm told that she did not ultimately write him up for that. During that same time period, February of 2025, Mrs. Farrar is alleged to have provided computer access, including employee access and access to the district's files and other applications and platforms other than email, by having direct communication with Mrs. Wadigi, providing her a password, communicating only with the IT department and not Mr. Watson, and telling Dr. Etheridge that he needed to mail the pay statements when she was, on the other hand, enabling digital access to Mrs. Wadigi. The allegation is that that access then continued on, and Mrs. Wadigi was getting employee access through digital and also through pay stubs all the way until April 3rd, when her access was inadvertently turned off.
Thank you. Thank you for that. Just want to make sure that we're clear on the statement of charges with the supporting evidence that has been produced and that has been shared. Are there any additional questions before moving on in the agenda? Thank you. There not being any. I do have item E, executive session. The governing board may vote to go into executive session, which will not be open to the public pursuant to ARS 38.43103A3 to receive legal advice from the board's attorney regarding legal issues related in general to termination proceedings and process under ARS 15.539. Do I move that we go into executive session. Do I have a second?
I second, Madam President.
Thank you. And Ms. Cantu, how do you vote?
I vote aye.
Thank you. Ms. Hernandez, how do you vote?
I vote aye.
Thank you. And Ms. Garcia, how do you vote?
Abstain.
Thank you. Please let the record reflect there's an abstention. And I vote aye, and motion carries. We're going into executive session. Please let the record reflect that it is 7:18 p.m.
Board President Hernandez?
Two.
Yes.
I rescind that motion. I'm going to state a second motion. Thank you. Thank you. I will keep that motion and I will add item number 2. The governing board may vote to go into executive session, which will not be open to the public pursuant to ARS 38.43103A3A1 to consider and discuss the continued employment of the district's Deputy Superintendent of Human Resources and to receive legal advice from the board's attorney regarding legal issues related in general to termination proceedings and process under ARS 539. With that, Ms. Cantu, do I have a second?
Second, Madam President.
And your vote.
I vote aye.
Thank you. And Ms. Hernandez, how do you vote?
I vote aye.
Thank you, Ms. Hernandez. And Ms. Garcia, how do you vote?
Abstain.
An abstention. And I vote aye. And motion carries. Please let the record reflect that it is 7:19 p.m. and we will proceed to go into executive session. Thank you. We are resuming the regular governing board meeting, bringing it back to order. And we are at item F. Please let the record reflect that it is 8:14 p.m. And we're going on to item number 2. I move that we adopt the amended statement of charges for termination of employment against Deputy Superintendent, Chief Financial Officer, Victoria Farrar, and to serve notice on Ms. Farrar of the governing board's intention to dismiss her at the expiration of 10 days from the date of service of such notice. Ms. Cantu, do I have a second?
Excuse me. Before you
second,
second
Madam
that,
We are in the vote.
I know that. But before
Ms. Cantu,
before the second, I was
proceed,
just
Ms.
going to
Cantu.
confirm that Ms. Farrar
Ms.
has
Cantu,
between a timeline,
your vote,
right,
Ms.
to
Cantu.
address
I
the
second
charge
and I
allegations.
vote
Thank
aye.
you, Ms. Cantu. And Ms. Hernandez, how do you vote?
I vote aye.
Thank you, Ms. Hernandez, and Ms. Garcia, how do you vote?
Again, just wanted to confirm that Ms.
Your
Farrar has
Your
a
vote, thank
timeline
you.
to
I vote
address
aye
her
and motion
allegations.
carries.
Is that
Thank
correct?
you.
Point of order, Lydia. Point
I
of order.
am moving on to item number 3. I move that we adopt the statement of charges for termination of employment against Deputy Superintendent of Human Services and Educational Programs, Human Resources, and to serve notice on Deputy of Superintendent of Human Resources of the governing board's intention to dismiss her at the expiration of 10 days from the date of service of such notice. Ms. Cantu, do I have a second?
Second, Madam President.
Thank you. And how do you vote?
I vote aye.
Thank you. Ms. Hernandez, how do you vote?
I vote aye.
Thank you. And Ms. Garcia, how do you vote?
And once again, speaking to Dr. Grajava,
Thank you.
also
And,
having a
I
timeline
vote aye and
of
motion
within
carries.
30 days upon service. Is that
We are-
correct?
we are
Just wanting
going-
to confirm that.
We are moving, it's 10 days from date of service of such notice as stated in the motion that was just stated. Going on to item G, announcement of future meeting dates and other routine information concerning the governing board. The next regular governing board meeting will be held on Wednesday, November 5th, 2025 at 6 p.m. at the Cartwright School District Governing Boardroom. A special governing board meeting, governing board study session will be held on Tuesday, October 28th, 2025 at 6 p.m. at the Cartwright School District Boardroom. Ms. Cantu, do I have a second?
I second, Madam President.
And how do you vote?
I vote aye.
Thank you. And Ms. Hernandez, how do you vote?
I vote aye.
Thank you. And Ms. Garcia, how do you vote?
I refrain.
Thank you. There's an abstention. And I vote aye and meeting is adjourned. Thank you. The time is 8:17 p.m.